I'm very honored and pleased to introduce Brian Tamanaha, who is a William Gardner Hammond Professor of Law at Washington University in St. Louis, Missouri. And he's certainly one of the most respected jurisprudence and law and society scholars today, worldwide. I may dare to say that he has served the ways of conceptualism and analytical jurisprudence to eventually state a realist conception of law, which has gained consensus among many scholars. I believe it would be right to say that he is one of the few law and society scholars who has managed to keep a meaningful conversation with analytical legal theories, which is not an easy thing to do. His work is taken seriously by a broad number of otherwise skeptical scholars who rarely engage in discussions about what many of them take to be merely assumptions. Some of his most renowned works include A General Jurisprudence of Law and Society, On the Rule of Law, which combines at the same time great simplicity in presenting the ideas and incredible depth in what they mean. It looks like if it had been written for his father, if my sources are right. And one of my favorite books, Beyond the Formalist-Realist Divide. And I should not leave aside, of course, Failing Law Schools, who made Brian a reference, and I'm pretty sure that even sometimes the order is different, who made him a reference in legal education and explaining the broken contract of law schools and the need for reform. So Brian, it is a great honor to have you here, and then the floor is yours for the next hour. Thanks for accepting the invitation.
Thank you all for coming. Let me apologize first. I don't speak French. I'm sorry about that. I never learned. And while I'm apologizing, let me also apologize on behalf of America for electing Donald Trump. I would like to blame it on temporary insanity. But it's actually interesting and relevant to our talk because there's a real strain of populism in the United States. I don't know if you heard about it, but populism was very big in the late 19th century. In fact, there was a party called the Know-Nothing Party. And the reason I mention it is when we talk about Dewey and Mead, for example, we talk about them as pragmatist philosophers, but they're also known as progressives. And progressives was a political movement at that time, a movement about educating people, about changing society, that traveled at the same time as the populist movement. So indirectly, that relates to what we're going to talk about today. So the title of the talk is Legal Pragmatism and Legal Realism. I wasn't sure how much background the audience would have, but from the program I could see there'd be many scholars of pragmatism and realism, so I'm going to assume significant amount of knowledge and just start from there. So what I propose to do is focus on the last 100 years. I can only talk about certain events, but I want to sort of start at the beginning and then bring it up to the current period and talk about the relevance of pragmatism, or to put it differently, how much difference did pragmatism make, or what kind of impact did pragmatism? And now, when I speak about pragmatism, I mean classical pragmatism, Peirce, Dewey, James, and Mead. So how much influence did pragmatism actually have on legal realism? And some of what I'm going to say might be surprising. It's actually something I learned in the course of preparing this presentation. I've been puzzled about the relationship between these two schools for a long time and really dug into it. And one of the things I'm going to focus on showing is that there's an elective affinity, that means a kind of correspondence or attraction between pragmatism and the common law system, and particularly the common law system in the late 19th century. And that elective affinity means two things, or has two implications. One is it suggests why common law jurists were inclined to accept pragmatic insights, but it also suggests that maybe pragmatic insights didn't matter that much. That is, that they were thinking along these lines all along. So I'm going to go through the talk. About the first half of the talk is going to focus on that. And I'm just going to give you background information about common law ideas at the time. After I do that, I'll talk about Holmes, the Metaphysical Club. I don't know if you heard about this, but I'm going to just speak very quickly about that. and then move on to talk about what concrete impact we can see in the work of Roscoe Pound, of William James, the impact that Dewey had in several different ways. About the 1950s, when jurists were saying this was the pragmatism was the standard philosophy in America, and then silence about pragmatism for several decades, and then a revitalization of pragmatism in the late 80s and 90s, silence again, and then I'll talk about the remaining relevance of pragmatism today. So that's an overview of the presentation that I plan to make. Okay, so whenever we have discussions of pragmatism and realism, there's a threshold problem of identifying precisely what you mean, because obviously there are different streams of pragmatism and different versions of realism. So I'm going to actually skip that debate because we couldn't get very far if we got into that. And I'll just acknowledge that there are different streams of pragmatism and focus basically on what they shared at a certain level of general, at a certain general level. About the realists, the legal realists are known to have, in modern legal theory, they're known as skeptics of judging. They promoted the idea that there's gaps and contradictions in the law, that when judges decide cases, they decide based on outcomes, and then they look for relevant legal authority to justify the outcomes. That judges, when they make decisions, are influenced by their background social views. And another wing of legal realism was that the social science, that we should apply the social sciences to understand how law actually works in practice. Okay, so those are the various streams, and I'm just, again, giving you a general overview. One of the complexities of pragmatism, legal realism, is at least the name emerged in a fight between Carl Llewellyn and Roscoe Pound, whereas from today's standpoint, it looks like they were more or less saying the same thing. So what I'm going to do when I talk about the realists is I'm just going to combine all of these figures and then talk about them individually, but not distinguish who's a realist and who isn't a realist. Okay, so let me begin with classical pragmatism. Again, I can see there are many experts on that here, so I won't go too much into it. But let's just focus on the general ideas. The pragmatists focused on providing an account of thinking and knowledge, which was really modeled on scientific inquiry. And then understanding scientific inquiry is continuous with all human inquiry, that there's no difference ultimately. They build on the idea that truths are things we work out in the world through the collective pursuit of projects. Knowledge is created in the course of our activities. So William James emphasized that pragmatism doesn't have any particular results, it's a method or an attitude, and he repeated this often, and Peirce did as well. So here's a quote from James. The pragmatist turns away from abstraction and insufficiency, from verbal solutions, from bad a priori reasons, from fixed principles, closed systems, and pretended absolutes and origins. He turns towards concreteness and adequacy, towards facts, towards adaptation to reality. Their ideas that beliefs, truths, knowledge, they're instrumental. That is, they serve us in our acting in the world, pursuit of our purposes. And they are held by us, and some of them, the world refutes them, essentially. In other words, plans that we have don't work out. We discard them, we reformulate them. Many beliefs are matters of habit that we just hold on to, and we continue to hold them. So let me give another quote, and I'm using different pragmatists just so you can see the flavor of what they're saying. So here's how Peirce described pragmatism. Consider what effects might conceivably have practical bearing. You conceive the object of our conception to have. Then your conception of those effects is the whole of your conception of the object. And the idea is conveying here is what concepts mean are the consequences that they have for us in our actions in the world. The value of pragmatism, according to Peirce, or in this passage, is that it reveals philosophical debates as certain philosophical debates as, quote, meaningless gibberish, one word being defined by other words and they by still others without any real conception ever being reached. So along similar lines, and I'm combining different statements from the major pragmatists, but on these general themes, let me offer another quote, and this is from Dewey. This taking into consideration of the future takes us to the conception of a universe whose evolution is not fixed, whose evolution is not finished, of a universe which is still, in James's term, in the making, in the process of beginning, of becoming, of a universe up to a certain point still plastic. So the pragmatists view social life as continuously evolving, a web of interconnected activities in the world. And again, the idea is this collective pursuit of projects that we have. Okay, so with these general pragmatist ideas in mind, now let me move to the subject of the early connection between classical pragmatism and the common law system. So discussions of pragmatism and legal realism often begin with the Metaphysical Club. I don't know if you've heard of this. There's actually a famous book called The Metaphysical Club, famous book by Manon, excellent book. It's interesting because for legal scholars, because Oliver Wendell Holmes was a member of the club, as was Peirce and James and several others. And his presence in the club leads to lots of speculation that Holmes himself might have contributed to pragmatism or might have been influenced by pragmatism or some combination of both, right? It's hard to separate these out. The difficulty with that is that the evidence suggests that Holmes really wasn't a member for that long and didn't go to that many meetings. And by his own account, he said he dropped out soon after, here's a quote, he soon dropped out of the band. But as it turns out, a different lawyer member of the club actually played an important role. And that member is Nicholas St. John Green. And I'm going to read a quote about something Peirce wrote about Green. Nicholas St. John Green was one of the most interesting fellows. He's talking about the club now. A skillful lawyer and a learned one, a disciple of Jeremy Bentham. His extraordinary power of disrobing warm and breathing truth out of the draperies of long-worn formulas was what attracted attention to him everywhere. In particular, he often urged the importance of applying Bain's definition of belief as that upon which a man is prepared to act. From this definition, pragmatism is scarce more than a corollary, so that I'm inclined to think of him as the grandfather of pragmatism. Now this is very high praise coming from Peirce. Now Green's ability to disrobe old formulas is displayed in an article he published in 1870 on proximate cause and remote cause. Green, in the article, he runs through the history of unsuccessful philosophical efforts to distinguish proximate from remote cause. He dismisses a metaphor that was used at the time called chain of causation. He described it as a dangerous metaphor. There's nothing in nature that corresponds to this. Such an idea is a fabrication of the mind. Every event has numerous antecedents and multiple attendant circumstances which are mutually interwoven, none of which can be singled out as the cause. So for example, he says, when a man drowns, there must be water and there must be the man, though people do not think of these necessary antecedents as the cause of the drowning. So what counts as the cause, and this is the key theoretical point he made, what counts as the cause depends on the purpose of the inquiry. The conclusion he draws is that the meaning of proximate and remote in law cannot be determined through philosophical or logical inquiry. He writes, the term proximate and the term remote have no clear, distinct, and definable significations. They vary depending on context. It's not fixed. It's not a fixed and constant division. Another quote. The meaning of the terms, proximate and remote, is contracted or enlarged according to what is the subject matter of the inquiry. So in torts, and use the proximate cause in different contexts, but in torts, proximate cause or a finding of proximate cause simply is whatever people choose to pick out from among the web of antecedent causes to attach liability to. And in contrast, calling something a remote cause reflects a decision to not impose liability. So Louis Manon, in the Metaphysical Club, suggests that Green picked up these ideas from an English jurist, James Fitzjames Stephen. In particular, a book published in 1863 called A General View of the Criminal Law in England. And it's Manon's identification of this book that actually led me to read this book, which I found extraordinary book. He exhibits a remarkably realistic view of law. And I'll give some details of that shortly. But for now, I just want to cite a passage from that book that actually resonates with the pragmatic understanding of belief and action. So this is, and again, this book was written in 1863 by Stephen. The desire to act and the desire to act successfully are ultimate facts in human nature, but we're so constituted that all actions involve belief, and the world is so arranged that all successful actions involve true belief. Hence, the ultimate reason for believing is that without belief, men cannot act. And the reason for believing what is true is that without true belief, they cannot act successfully. Thus, the advantage derived from true as distinguished from false belief is the reason for believing what is true. If all the affairs of life, moral and intellectual, education included, could be conducted as well by a person who believed that twice 2 makes 6, as by one who believed that twice 2 makes 4, there would be no reason for believing the one proposition rather than the other. Hence, belief is not a mere impression which the mind receives passively from the contemplation of facts external to it, but an active habit involving an exertion of the will. Now, these passages really resonate with a lot of early pragmatist writing. So just to give you an example, I want to cite a passage from William James, much shorter. Beliefs, in short, are really rules for action, and the whole function of thinking is but one step in the production of habits of action. If there were any part of a thought that made no difference in the thought's practical consequences, then that part would be no proper element of the thought's significance. And again, think about Peirce's statement that what conceptions are the consequences of those conceptions. So this is again Stephen, and as with Green, Stephen expresses in the book a thoroughly pragmatic view of theories and concepts. They're essentially useful for analysis. And he discusses legal concepts in this way. So I'm going to give you a few examples. When he talks about crime, he says, what constitutes a crime arises not from the nature of the acts contemplated, but from how they're treated. So one of the criticisms he suggests in the book is that theorists spend too much time trying to distinguish contracts from torts. He says this effort is futile. Whatever is within the scope of the penal law is a crime. Whatever is a ground for a claim of damages, as for an injury, is a tort. But there's no reason why the same act should not belong to both classes, and many do. He goes on to say that there can be no theory of torts, because a tort is whatever private parties are allowed to pursue for wrongs not involving a contract. Again, a quote. So tort is thus a most comprehensive word and includes a vast number of actions which it would be impossible to class under any rigid definition. Now, throughout the book, Stephen talks about, but he de-emphasizes theoretical debates. For example, responding to concerns about vagueness of the key notions of malice and maliciousness, and these are central to criminal law. Stephen says the difficulty lies not in the words, but in the theories by which we try to explain them. He argued that there's actually no problem in practice because the meanings of the terms are filled in by the moral sentiments of the community and the people making judgments in the context of these crimes. So, quote, whatever may be the want of precision of these words, it has in practice been remedied by experience. Along similar lines, Stephen argued that law is not concerned with questions about moral truth. The law, quote, has nothing to do with moral truth. It is an exclusively practical system, invented and maintained for the purpose of an actually existing state of society, and the answers to moral problems are supplied by the moral sentiments of the community. Now, Green and Stephen are seldom mentioned in discussions of classical pragmatism, certainly among philosophers. Menand is a notable example. And I want to make clear that by talking about them, I don't mean to suggest that they themselves were philosophical pragmatists. My point precisely is that they were not. And yet, nonetheless, they express recognizably pragmatic attitudes and views. So this goes to the point I raised at the outset. This is suggesting about the idea of elective affinity between the common law system and pragmatism. And I want to flesh out that idea just a little bit. And in order for me to do that, I'm going to talk a bit more about Stephen's ideas. But first, let me tell you something about the common law system, and this differs from civil law systems. In the 19th century, the common law system was thought of as a craft. You didn't actually learn to become a lawyer by going to law school. You learn to become a lawyer as an apprentice in an office. And the law schools actually had to establish themselves in universities against a great deal of skepticism about whether law should be taught in a university. So there was lots of talk about it at the time. And one way in which legal scholars established their position was to make the claim that law is a science. If you look at the literature at the time, you'll see claims made by professors and theorists that law is a science. But at the same time, there were frequent responses from practitioners, lawyer practitioners, ridiculing this idea, saying law is not a science. It's actually a practical activity, much like Stevens described. And Stevens was a practicing lawyer. So I want you to have that backdrop in mind as we understand who it is we're talking about when we talk about law as a system of logic. And I'm going to suggest that was taught by theoretical jurists. And at the time it was a debate within the American legal community about that, whether or not it's true. Okay, so let's talk about Stevens again for a little bit, because you get a sense from his description what the common law self-understanding was about. He spent the second chapter, and the first chapter is just a very short chapter on definitions, which is how books typically start. The second chapter is a very lengthy historical chapter in which he talks about the development of the common law for the last 800 years. And he describes it, the law, as the product of a combination of political events leading to legislation, things done by kings, as well as court decisions. And the aggregate effect of this was a kind of hodgepodge mix of judge-made law and statutes, and many of the statutes were what he called piecemeal, dealing with particular topics or trying to solve a particular problem, but it was never comprehensive and it was never coherently constructed. The common law system wasn't built, for example, like a code in which someone sat down and organized all of the parts. It was just developed along the way. So the result of this is, and he was writing, as I said, this is in 1863, is something of a mess. It wasn't really organized. Blackstone organized the common law in separate doctrinal areas and tried to focus on some core ideas within it. But the reality of the law, as Stevens described, was just something that evolved that way. So let me give some statements as he's providing this about what courts have done. So courts have from time to time introduced considerable modification into the principles of the common law and even into the enactments of the statute according to their views of justice, symmetry, or convenience. So what that means, and I want to focus on those words, justice is about our sense of justice and fairness. Symmetry is about logic, trying to make it organized a little bit. Convenience is utility. Convenience is things that work for us and satisfy our needs. So the overall result, as I said, was an unplanned combination that he called entirely unsystematic and irregular superstructure of legislation. And although he described the legal system and the legal rules as generally sound, he suggested that the law was destitute of arrangement and deformed by strange technicalities. And again, this is just because it just developed in the aggregate without anyone ever thinking about it and having it cohere as a whole. The next key statement he made, and I'm focusing here toward the end of the book, is a statement about judicial legislation. In fact, that's a subtitle in the chapter. And the reason I say that is because there's a story in the U.S. In legal theory that 19th century judges didn't legislate, and that it was widely accepted that they didn't legislate, and that this wasn't acknowledged until Benjamin Cardozo announced this in the nature of the judicial process, and the realists disclosed this to the world. That story is just really not true. It was well understood in the 19th century that judges legislated. And as I said, Stephen titled the section Judicial Legislation. So let me read the passage to you. The fact that, under the fiction of declaring the law, the judges in reality make it, has been recognized by everyone who has studied the subject with candor and intelligence since the days of Bentham at least. Henry Maine said the same thing in Ancient Law, which was published 2 years before that. And Stephen then proceeded to list a number of really significant examples in which judges modified not just the common law, but judges modified statutes through judicial interpretation. But the problem, he said, at the end is that the system has all of these problematic aspects because they didn't openly acknowledge that judges legislate. So, again, quote, "The consequence is that the judges legislate with their hands tied and are obliged to perpetuate many rules which, to their knowledge, are absurd and mischievous." So one of the ways they changed the law was by declaring legal fictions. I don't know if you know about this, but the common law system's full of fictions. Fake parties, fake to satisfy pleading requirements, and all sorts of things. So using fictions and simply reinterpreting the law without announcing it solved problems in particular areas of law, but overall it entrenched a system that had all kinds of twisted aspects to it. So, and this is again consistent with the common law idea. The common law theorists used to talk about the common law. One of the metaphors is a ship changing planks while sailing, putting in new planks. So it's the same ship, but new pieces are being made at the same time. Or an even better analogy was about a house that's new wings are added, old outdated parts are remodeled. So it keeps the basic footprint, so that's still the house, but over time it's updated and made anew. The difference is the 19th century had remarkable social, economic, and political transformations. This was really the century in which we went from a rural, and now I'm talking specifically about the United States, but also happened in England, from a rural agrarian society to modern mass society. And it was in the course of the century, particularly towards the latter part of the century. And this had consequences for the law, because the legal doctrines, ideas of individualism, for example, ideas of laissez-faire, that were adapted to a different socio-economic arrangement no longer fit towards the latter part of the 19th century. And as a result of that, there were lots of calls for reforms. So this change in social organization created a lot of pressure. And this pressure was being manifested in calls for legislation. Legislation, and the familiar examples of that we have are social welfare legislation. Pieces of this were coming into place in the 19th century, much of which was not consistent with the doctrines within the common law. All right, now let me end the discussion of Stevens, just by focusing on some very pragmatic, if I can use the term, realistic observations made toward the end of a book. One thing is that he denied that there can be a science of the law in the abstract sense. He basically said that the job of jurists really is to advise legislators about the reality of law on the ground. It's the province of the jurist to point out the limitations which the nature of human affairs imposes on the legislature and the character of the problems which he will have to solve. He urged jurists to pay attention to how law works, and I'm raising these because these are later realist themes. And he said that the job of jurists is to advise legislators that if you enact this law, and if you carry out that law consistently, the consequences will be so and so. So again, this is focusing about the implications of the law in actual application. Thus, the first service rendered by the jurist to the legislator is to submit to him the series of alternatives placed at his disposal by the state of human affairs. In these closing passages of the book, Stephen also just flatly denies, I'll quote it, "There is no such thing as natural law." And this is natural law in the old natural rights sense, and then prior to that in the old scholastic natural law sense. Law involves human affairs, which vary by place and change over time, although there are certain commonalities related to shared human nature. So this led Stephen to make another observation that later became central to sociological jurisprudence. And this is about how social relations are fundamental. So I'm going to read this passage because if you're familiar with sociological jurisprudence, this is a core idea within it. In the vast variety of changes which have taken place from the book of Genesis to the present, law, no doubt, has played a most important part. But it has been only one of many agents by which our existing conceptions of society and of our human relations have been formed. Hence, the relations of men to each other are antecedent to, and to a great extent, independent of law. The aggregate of them for the time being constitutes human nature for the time being, and laws, which are framed on a true view of human nature, may properly be called natural laws. The phrase, a natural law, is therefore thus analogous to the phrase, a natural manner. They mean, respectively, laws or manners agreeable to the nature or state of things existing at the time. So the point he was making is that social relations are fundamental. And they're echoes of Eugen Ehrlich's understanding of living law, the idea that there are actual social behavior and social rules that people follow that essentially or functionally are equivalent to law. And it's these things that legislators must pay attention to when they enact laws, because those laws of then are going to work or not work as a function of how they interact with these fundamental social activities. Okay, so that's Stevens. And again, I've spent a lot of time on him. I was just fascinated by what he had written. And I did much of this research for this talk. So now I want to just talk about what I call the elective affinity between the two, and just focus on two basic themes. And by elective affinity, again, I mean ideas within the common law that resonate with ideas in pragmatism in a way that suggests a kind of sense in which they're compatible, but more close than that, kind of attractive ideas to one another. So the first, and again, I'm just going to talk about two of these. The first is that a core pragmatist idea is that knowledge is a collective product that continually advances through a community of inquirers taking actions based on beliefs and theories and observing the consequences of those actions. Beliefs are always subject to revision by future consequences or by existing facts, considering existing facts that previously weren't examined. As Dewey put it, every proposition concerning truths is really, in the last analysis, hypothetical and provisional, although a large number of these propositions have been so frequently verified without failure that we're justified in using them as if they were absolutely true. Now this is an evolutionary view of knowledge, knowledge developing over time through our joint projects. These same ideas can be transposed into a common law context. Think of judges as a community of inquirers. Legal doctrines or beliefs, and decisions in individual cases are actions based on these beliefs. And the consequences of these actions are then considered by legal officials and by judges in future instances. Viewed in the aggregate, the common law judging is a process of absorbing lessons about what doctrines work or fail in connection with expected or desired social consequences. As Stephen put it, decided cases embody the result of an immense amount of experience and of shrewd practical acquaintance with the subject matter to which it refers. Legal doctrines remain in place for lengthy periods of time until they are revised because they no longer work as expected or desired, or powerful social actors protest their consequences and resist them, or because new circumstances render them obsolete. Then adjustments are made through legislation and more often through judicial legislation, which is essentially changing the law through interpretation. This view of the common law also resonates with Peirce's notion of synergism. As he explained, this is founded on the notion that the coalescence, the becoming continuous, the becoming governed by laws, the becoming instinct with general ideas, are but phases of one and the same process of the growth of reasonableness. Thus, the common law evolves in much the same manner that pragmatists claim knowledge evolves more generally. All right, now the second, this is just as I said, going to identify only two factors. The second essential commonality between common law systems and pragmatism follows from the historicity of law, the idea that law develops over time. The constantly evolving decentralized working of the common law system cannot be captured by strict categorization, by necessary truths, logical deductions from established principles, or a priori reasoning. There are always variations, changes, adjustments, and borderline situations. Logical consistency is an important consideration in law, but so too are justice, values, social objectives, and convenience, as Stephen said. Nothing in the law is fixed or universal. It all changes in relation to society. But by society, I mean everything. I mean the economy, politics, technology, the environment, ecology. So recognition of these aspects of the common law led Green and Stephen to reject analyses of concepts based on their purported nature or essence. Instead, they devised categories and based their analyses on general patterns or responses. There's no point, they said, in trying to analytically distinguish proximate from remote cause or crimes from torts, because what these terms mean depends not on an inherent nature or conceptual necessity, but how they're treated in practice. Okay, owing to these two commonalities, as I suggested, there's a close compatibility. Now let me turn to the legal realist. So I'll finally actually get to the topic. But I wanted to set it up that way because I want to now evaluate claims we make about how much the realists were influenced by pragmatism. So let's begin with Holmes. He's the starting point. As I said, it's really kind of tantalizing to think about Holmes and his participation in the metaphysical club. But the general agreement is he wasn't there for very long. And it's really not known what contribution he made or how much he was influenced by their ideas. What we do know is that he said disparaging things about Peirce, as well as about James, about their views. He complimented Dewey, but the compliment came decades later. So it's hard to know what that meant at the time, particularly because he began setting out his views really in the 1870s. Okay, so I'm gonna give you some of the Holmes positions that have been identified by pragmatist scholars as evidence of pragmatism or as an indication of pragmatism. By the way, for those of you who are interested, a terrific scholar of pragmatism and legal realism is Susan Hack. She does amazing work. So these pieces that I'm going to identify come out of an article that she published in the American Journal of Jurisprudence. Now, as I say these, I'm actually going to suggest a contrary interpretation than the one she took. So here's Holmes's famous statement: "The life of the law has not been logic, it has been experience." So this statement's been identified as a really example of classical pragmatism, and indeed it is. But the problem is that this statement was not original to Holmes, and really it wasn't exclusive to Holmes. So a decade before, in 1873, the lawyer editors of the Albany Law Journal made exactly the same objection in quite similar terms. I'm going to read it to you. Now again, as I say these, I want to just have you keep in mind, earlier I made a distinction between how practitioners viewed law and how theorists viewed law. And I'm going to suggest that Holmes was challenging theorists, but practitioners agreed all along. So here's the statement, and this is the lawyers, and this Albany Law Journal was one of the most prominent journals at the time. And this is them describing the view that they were objecting to as wrong-headed. "If circumstances arise to make the application of the rule unfavorable to the best and broadest interests of the people or the state, and an abrogation of it is sought on the grounds of expediency, the jurist is ready with the argument that it's better that the law, once founded on reason, should preserve its symmetry and logical continuity than that the innovations of experience should be allowed to mar its beauty and endanger its perfected reason." And the editors just scoffed at this view and said it's just notoriously untrue to assert that the law is the perfection of reason. And as I said, and they suggested in the article that it's theorists, that only theorists think that practitioners have a completely different view of the system. Here's another practitioner view from the time. "This is not the jurisprudence of a system of commands, it's the jurisprudence of welfare, wrought out by free reasoning upon the facts of a case." Here's another practitioner, and this is really interesting because this is written in response to Holmes. Holmes's argument in The Path of the Law that saying law's not logic, people need to stop thinking about it this way. So a practitioner responded in the Law Journal saying, "The learned judge finds it necessary to expose a fallacy, namely the notion that the only force at work in the development of law is a logic." And then he asks, "But is this a common error? I cannot believe that this particular fallacy has taken a deep hold on the profession, nor can it be admitted for a moment that judges have failed hitherto to decide cases according to their ideas of the general good." Now let me identify some other views that have been identified by pragmatists as examples of Holmes's pragmatism. and this by many commentators, his prediction theory of law. This idea that what law is a prediction of what judges will do. Again, Holmes wasn't the only jurist to make this assertion. Frederick Pollock, he's a great English jurisprudent at the time, wrote earlier than Holmes said this, and I quote, "The object of legal science, like natural science, is likewise to predict events. The particular kind of events it seeks to predict are the decisions of courts of justice." Pollock actually, unlike Holmes, explicitly included judges within his prediction theory as well. He suggested that judges, following on the whole the same process as advising counsel, makes a scientific prediction with reference to an ideal standard of the correct legal answer. So this is, again, another view identified, and Hack in particular identifies this as an example of his pragmatism. But as I said, others said the same thing at the time, and from a lawyer's standpoint, the prediction theory makes perfect sense, because that's in fact what practicing lawyers do as they're advising clients in cases. And when Holmes introduced the prediction theory of law, he introduced it in the context of a lawyer advising clients. So if you take this statement out of context and turn it into a theorist understanding the theory of law, of course it's going to make no sense to you. But if you read it the way it was written, it's actually a commonplace among lawyers. So here's another example identified, and this again comes from Hack. She identifies Holmes's assertion that judges render decisions relying on perhaps unconscious policy preferences. So this is the realist insight, that when judges decide cases, they're relying on their background social views, consciously or subconsciously. This was openly stated by many other jurists at the time. So let me just give you just a couple of examples. This is from an 1893 article in the American Law Review. This was probably the most prominent law journal. Holmes actually worked on the journal when he first began. The title of the article, just in case anyone missed it, was "Politics and the Supreme Court of the United States." The author declared, "To say that no political prejudices have swayed the court is to maintain that its members have been exempt from the known weaknesses of human nature." He suggested that in cases where no clear precedent exists, quote, "a judge's conclusion will be largely controlled by the influences, opinions, and prejudices to which he happened to have been subjected." Another very well-known jurist, Christopher Tiedemann, stated, "The bias and peculiar views of the individual judge do certainly exert a considerable influence over the development of the law." And as I said, there are many statements to this effect. I'm just picking out a few. Let me move on to another position identified with classical pragmatism, and this is the idea that Holmes' idea that judges should be forward-looking, instrumental, should develop the law in relation to the current generation, and each generation taking its own step. This view, again, I'm going to tell you, was very common, and quote from another well-known judge. I'll just pause to say something interesting about jurisprudence and history. In the end, we pick out famous figures, Holmes and Pound, and we only talk about those. But actually, if you go into the historical record, you'll find lots of other people who were famous at the time and influential at the time, but didn't make it on the list of famous people. So if you go and look at their views, you'll get a flavor of what other people were thinking. So our tendency is to anoint the hero, and that hero was the great forward-thinking person. And indeed, Holmes was. Nothing I'm saying detracts from that. What I'm suggesting is he wasn't unusual. So here's LeBaron Colt. He was a Second Circuit judge. He was actually on the short list to be appointed to the United States Supreme Court. Now he didn't make it on there. But this is a 1903 address to the American Bar Association, which at the time was the association of all the prominent lawyers. And this was the annual address. Obviously it was to an important setting of lawyers. So he tells the audience, the special role of courts has always been to keep the law in harmony with social progress, to make it more reasonable as social necessities and public sentiment have demanded. Now a longer passage I'm going to quote. Ever recognizing that the matter changeth, the custom, the contracts, the commerce, the dispositions, educations, and tempers of men and societies, They have conceived theories, invoked doctrines, and inaugurated instrumentalities to relieve the situation. Here he's speaking about judges. They have carried on judicial legislation from the infancy of the law in order that it might advance with society. By the adoption of broad and elastic rules of interpretation, they have maintained in large measure the supreme law of the land in harmony with national growth. And he said this multiple times in the article. Again, these are identified as legal realist insights in particular, but here's a judge saying this openly, and again, I want you to see the audience. These are prominent lawyers. And he ends the article by repeating, the law should always be viewed from the standpoint of society and not from the standpoint of the law itself. The law is made for society and not society for law. Society is the master and the law is its handmaiden. So this is the instrumental view of law. It was already espoused by many leading jurists at the time. And this is what resonates with pragmatism. So when we look at Holmes and we talk about his instrumental view, his forward-looking, look at the law, evaluate its context, I want to suggest that that was a view of the common law generally. And part of the reason for it, and this gets lost in the overall picture, is instrumentalism itself was introduced into the common law system a century earlier by Jeremy Bentham. Utilitarianism takes a consummately instrumental view of law. Law is an instrument to maximize the aggregate of social pleasure over pain, to put it simply. Now, Bentham was criticized for his really sharp criticisms, very funny actually if you read them, criticisms of the common law, but he had a huge impact, and there were significant reforms that followed from his writings. And let me give an aside just to draw out all the connections that are going on here. And this aside comes from William James's dedication in his book on pragmatism to the memory of John Stuart Mill, from whom I first learned the pragmatic openness of mind and whom my fancy likes to picture as our leader, were he alive today. Now, of course, Mill developed Bentham's utilitarianism, and he too espoused an instrumental view of law. Furthermore, in the legal context, an instrumental view of law was prominently advocated in the 19th century by Rudolf von Jhering in his famous books, Laws and Means to an End and The Struggle for Law. And these books made an impact in the United States, and Holmes was very familiar with Jhering's writing. So Jhering basically wrote that law is an instrument used by individuals and by groups to advance their objectives. It was a kind of social instrumentalism that he advocated. And he was, I'm going to suggest, instrumentalism was already the reality of law, and that as theorists often are, they're behind the times trying to articulate in theoretical terms things that are already going on. But let me read another quote, and this quote comes from Jhering, again much earlier than Holmes, about logic in law. So he writes, "Let us break the charm, the illusion which holds us captive. All this cult of logic that would turn jurisprudence into legal mathematics is an error and arises from a misunderstanding of law. Life does not exist for the sake of concepts, but concepts for the sake of life. It is not logic that is entitled to exist, but what is claimed by life, by social intercourse, by the sense of justice, whether it be logically necessary or logically impossible." This is precisely the view Holmes articulated later in the Common Law and the Path of the Law. So if holding these positions makes Holmes a pragmatist, then many other jurists at the time were also pragmatists, the vast majority of whom likely had little or no exposure to the early pragmatic writings of Peirce, James, and Dewey. At the close of her essay, Hack announced this conclusion: Holmes may not be officially on the team, but there is certainly much of the spirit of classical pragmatism in his thinking. She's absolutely correct as far as it goes. But what I'm suggesting we need to consider is whether this is because Holmes was persuaded by his exposure to pragmatic views, or because many jurists already viewed law these ways. The pragmatism that we tend to see in Holmes' views of law, that was how all forward-thinking jurists at the time thought. Historical jurisprudence viewed law as continuously developing in connection with surrounding social factors and needs, and jurists combined historical jurisprudence, historicism, with the instrumental view of law as a mechanism to advance social ends. This combination of views was held by Stephen, you can see it in his writings, as well as Oliver Wendell Holmes and other jurists. Okay, now let me turn, and I'll cover the rest more quickly, to other leading legal realist jurists or contributors to legal realism. So Roscoe Pound, in his famous essay Mechanical Jurisprudence, critiqued what he saw as the tendency of judges to rule in a mechanical fashion without considering social circumstances or consequences. And he drew explicitly from James's Pragmatism book, which had recently come out. So here's a quote from Pound. Excuse me. "I've referred to mechanical jurisprudence as scientific because those who administer believe it's such. But in truth, it's not science at all. We no longer hold anything scientific merely because it exhibits a rigid scheme of deductions from a priori conceptions. In the philosophy of today," and now he's referring to James, "the theories are instruments, not answers to enigmas in which they can rest." That's a quote. "The idea of science as a system of deductions has become obsolete, and the revolution which is taking place in other sciences in this regard must take place and is also taking place in jurisprudence." So Pound is explicitly drawing on James in this context. And later in the piece, he quotes a passage from James's description of the flawed eternal quest of philosophers to find universalistic solutions by using magic words. Now, Pound was amazingly prolific. I don't know what the total articles were, but he's unbelievable. And the thrust of these articles at the time, and this is about 1908, 1910, 1915, 1920, is that the law was lagging behind rapid social change. And the judges were hamstrung, much like Stephen said 4 decades earlier. We needed to have significant social changes brought by legislation, social welfare legislation in particular. Judges were standing in the way, and they needed to let this happen. Once this new legal basis was provided, things would go on as before, and everything would be fine. And the basic argument he pressed is one that I suggested earlier, that these 19th century doctrines set into the law, individualism, had to give way because in modern mass society, everything is socially constructed in terms of all the social constraints, large corporations, large government. We can't have freedom of contract between one individual worker and a corporation. We have to be able to allow them to collectively negotiate. We have to allow restrictions on your freedom of contract. And this, he actually wrote an article called The Freedom of Contract, laying all of this out. But what's interesting about this period is he doesn't actually cite the pragmatists very often. More often, he talks about sociological jurisprudence. And I raise this because one of the questions is, what's the relationship of sociological jurisprudence to pragmatism? So he's many, many articles. I went through Pound. I clicked on how many times he cites pragmatism. It's just, you can do everything by computerized research these days. It's actually amazingly easy to do compared to before. So he seldom mentions pragmatism as a philosophy, but he has a pragmatic mindset. So he doesn't have to mention it, right? It's there in the way he's looking at things. But now let me talk about sociological jurisprudence. So he wrote several articles at the time extensively discussing sociological jurisprudence. And the way to understand this, we look at that today as evidence of pragmatism, but that was actually itself a reflection that this was the period of the establishment of the social sciences in the universities. So they were establishing political science departments, economic departments, sociology, anthropology. And there was this general faith that social science was going to help us find some answers. Now, so Pound was advocating sociological jurisprudence / pragmatism without being really clear about where one left off and the other began. Now, not everyone agreed with Pound. There were others at the time advocating social sciences in law. Some really quite famous ones. Melville Bigelow, he's the dean of Boston University. William Draper Lewis, the dean of Penn. So this was all right at the turn of the century. Science needs to incorporate, law needs to incorporate awareness of science. Now let me say some things that the critics of Pound wrote, because this is relevant to pragmatism. They asked Pound, well, what do you mean by sociological jurisprudence? And what answers does pragmatic philosophy provide? So he said, well, sociological jurisprudence comes to basically 4 ideas. One is looking at how law actually works, rather than abstract content. The other is to see law as a social institution that can be improved through effort. The third is to focus on the social purposes of law. And the fourth is to see legal rules and principles as guides to results which are socially just, and less as inflexible molds. So that's his vision of sociological jurisprudence. On pragmatism, he admitted, and this was in 1912, unhappily the discussion of general principles goes on, and a pragmatist philosophy of law has yet to come. In later works, he suggested what pragmatism came to was his theory of social interests. His basic idea was that what law should do is find the correct balance of competing social interests. Now again, I want to focus on what critics said. So Pound said the goal of law, and this he attributed to pragmatism in a couple footnotes, although he never explained the connection, is to maximize the balancing among competing social interests. Again, I want to talk about what the critics said. They said that the problem is, Pound, you haven't given us any standards or principles for the balancing. One critic wrote, it does not suffice to shuffle the massive wants and claims of the litigants into a confused pile and then give effect to as many as we can insofar as harmony will permit. He was ultimately saying we need standards. Some social demands are unworthy. Some have greater value than others. But to make these determinations, we need standards. This same objection, I want to bring it back to pragmatism, was voiced against critics of pragmatism at the time. The president of the University of Chicago, Robert Hutchins, also, he attacked Dewey's instrumentalism on the same grounds. He wrote, we know that there's a natural moral law, and we can understand what it is because we know that man has a nature and we can understand it. The difference between us and Mr. Dewey is that we can defend Mr. Dewey's goals, we can argue for democracy and human ends, and Mr. Dewey cannot. All he can do is say he is for them. He cannot say why, because he can appeal only to science. And as I said, there were many other critics of Dewey at the time saying the same thing. What's interesting about Hutchins is that he was the dean of Yale Law School at the time that realists were beginning to emerge. And he began very supportive of realists, brought them onto the faculty. But by the 1940s, he was turning away against legal realism because general views at the time was that it reduced to the idea that law is a system of power. There's lots more to say about this, actually, but I have to move on. Except to say that this problem was a problem for pragmatism from the outset. And Menand, as I said, it's a great book if you want to read something about the origins of pragmatism, observed the problem with classical pragmatism is that it takes interests for granted. It doesn't provide for a way of judging whether they're worth pursuing apart from the consequences of acting on them. Now, in fairness to pragmatism, this is actually the dilemma of the modern age. Natural law theories lost their hold in the 19th century, and since then no theories convincingly provided standards for value. So the criticism against pragmatism on this score may well be correct. On the other hand, as far as I know, no other solutions have been provided to these issues. So let me talk about John Dewey very quickly. For those of you who don't know, he actually, one influence is beneath the surface, and that is he taught a class in legal philosophy at Columbia for 5 years with a law professor, Edwin Patterson. And Patterson recounts later that there were lots of attendees of the class who later on became law professors. So you would imagine that they absorbed Dewey's ideas. More specifically, he wrote 2 really brilliant articles. One is called The Logical Method in the Law, which I won't go through now, but it said some really, I think, terrific, still, some of the best writings about it. Basically, the idea is law isn't judges don't decide cases by applying a pre-existing law to the facts, but it's some interaction between the law and the facts, operating at several stages until you come to a result. Logic is a part of the process. He never denied that, but consequences matter as well, along with background views. For me, the most illuminating thing about this article is his distinction between the logic of decision-making and the logic of exposition. Basically, he's saying written opinions are not meant to tell you how the decision was made. They're meant to justify the decision and provide guidance for future judges. So it looks logical because of course, you're going to make it as strongly as you can. And that will be more helpful to future parties trying to figure out what the law is. Another really excellent Dewey article, but not often mentioned, is called The Historic Background of Corporate Legal Personality. in the beginning of the article, he makes the famous pragmatist distinction. He said there are two types of approaches, proceeding in terms of essential and universal nature, or proceeding in terms of consequences. So he begins by talking about what the word corporate personhood means, or personhood means. Natural persons, he talks about all of these concepts, subjects, real, natural, artificial. And he basically shows at the end that you can go either way. He says each theory has been used to serve the same ends, and each theory has been used to serve opposing ends. So ultimately, he says, the decisions are political issues and decisions traveling under the guise of legal considerations. Felix Cohen's, I'm just going to mention one, Transcendental Nonsense and the Functional Approach article, is a great example of applied pragmatism. He basically does what Dewey did in corporate law, and he applies it to a bunch of other legal concepts. So if you ever want to see a perfect example, that's the place to start. Okay, let me jump ahead because I'm running out of time. So now I want to talk about the... Okay, so I'm going to jump really ahead. Let me just say very quickly, a published article in the 1950s said this, and this is about the state of legal philosophy in America today. The fundamental legal philosophy in America is pragmatism. Its best known instance is, of course, sociological jurisprudence as developed by Roscoe Pound. No American theorist today claims that he's not as concerned with Pound with the social nature of law and the actual social effects of legal doctrines, substantially all except the basic shift in viewpoint for which he's battled so valiantly during half a century. What's interesting about this, so in the 50s they're saying, the American philosophy of law is pragmatism, and pragmatism is sociological jurisprudence. The two become identified, and there's no real separation between the two. What's interesting is although this was being said, there wasn't really much talk about either pragmatism or sociological jurisprudence. And one of the things I want to suggest is once you get the insights of pragmatism, it doesn't really matter. In other words, once you become pragmatists, there isn't that much more to say about it in terms of the original pragmatic challenges to how philosophy was done at the times. Okay, I will jump ahead and say the revival of pragmatism. In the late 80s and 90s, there was a sudden revival of pragmatism. I was one of them. People talking about it from across the political spectrum, critical legal studies, from Morty Horowitz to conservatives like Judge Posner. And the revival of pragmatism in this context, I think, had much to do with the popularity of Richard Rorty's writings, which were big in philosophy at the time. So what legal theorists did is look for their favorite pragmatists. Essentially, it was an effort to enlist pragmatism to fight what they saw as a reemergence of the formalism, textualism, Scalia, Easterbrook, and so forth. The thing about pragmatism is, just as in the past, talk about pragmatism rather quickly died away. We can talk about that in the questions if we have time, but I'll just say for the same reason. Once you realize pragmatism doesn't support any particular substantive view that you have, and your reason for raising it was to enlist it to back that position, there's not that more that you're going to get out of it. Okay, let me go to, actually I had a very nice section on Posner, but I'll leave that out. Actually I won't. Let me just take 1 minute. So the one person who continues to talk about pragmatism is Richard Posner. Amazing theorist, a marvel. So pragmatism for him is about pragmatic judging. So he says the ultimate criteria of pragmatic adjudication is reasonableness. Quote, in fact, there isn't too much more to say to the would-be pragmatic judge than make the most reasonable decision you can, all things considered. I just want to make one point about this. That is, pragmatic philosophy doesn't necessarily promote or support pragmatic judging. And Posner acknowledges this. It all depends on the consequences of pragmatic judging. In other words, if you have a system now where all the judges are deciding what's reasonable, the consequences might not be so good. Why? Well, because they have different views of what's reasonable. So you have variation in law, you lose predictability. So a pragmatic judge, and I'm going to read him, so Posner recognizes it. It would be entirely consistent with pragmatism that the philosophy not want judges to be pragmatists. It all depends on the consequences. Okay, so I will end now by saying the one remaining area where I think pragmatism is still relevant, and that's in the area of analytical jurisprudence. Let me read some statements from analytical jurists. This is from Joseph Raz. A theory consists of necessary truths, for only necessary truths about the law reveal the nature of law. We talk of the nature of law or the nature of anything else to refer to those of law's characteristics which are of the essence of law, which make law what it is. Jules Coleman, the descriptive project of jurisprudence is to identify the essential or necessary features of our concept of law. A theory of law must consist of propositions about the law which are necessarily true as opposed to merely contingently true. That's from Julie Dixon. Because only necessarily true propositions about law will be capable of explaining the nature of law. Scott Shapiro, to discover the law's nature would be in part to discover its necessary properties, that is, those properties that law could not fail to have. Robert Alexie, thus, for the question, what is the nature of law? One may substitute the question, what are the necessary properties of law? Essential or necessary properties of law are those properties without which law would not be law. Okay, this is precisely the kind of wrong-headed philosophical approach the classical pragmatists challenged over a century ago. So let me end by repeating James. Pragmatism is the attitude of looking away from first things, principles, categories, supposed necessities, and of looking toward last things, fruits, consequences, and facts. Thank you.